Hi, in this video we talk about how physicians can tackle the legal and regulatory issues that often arise with health coaching. I'm Michael H. Cohen. I'm founding attorney of the Cohen Healthcare Law Group. We help healthcare entrepreneurs just like you navigate the very complex healthcare and FDA legal issues so you can launch or continue to scale your health and wellness service or product. And we've helped over 1,000 clients in recent years. Now, health coaching, as we know, is a popular way to deploy all the gifts and skills that many people can bring to help clients in need of better health, be it physical, mental, spiritual, environmental. And today, there's some very large professional organizations devoted to health coaching, and they're expanding the legal boundaries around what health coaches can do just by fiat and some battles as well. But the challenge is this. Back in the 1880s, the states decided that they would license practices involving healthcare or health and wellness, and that anyone who said that they were practicing medicine had to have a license from the state to do so. So one practitioner, his name was Dent, and he challenged these laws. The case went all the way up to the Supreme Court, and he did not make a dent. The court actually affirmed the state's right to license medicine and to decide who can and cannot get a license. So that decision still holds today. The problem is that the definition of practicing medicine is very, very broad, and it includes anything that could be considered diagnosis, diagnostic, treatment of any health condition. So it's very broadly written and interpreted that way. And many of the legal definitions in different states of practicing medicine do not depend on whether or not the practitioner charged a fee for the service. So, if you find some newfangled technique to help people get over this or that, and you think it's miraculous, but you limit yourself to family and friends, it's still possible that you might have crossed the line into the practice of medicine. So these broad statutory definitions create legal peril for the charge of practicing medicine without a license. And this is where all my healthcare legal research started. The peril can affect at least two different audiences. So one, if you're a health coach and you're not licensed, you could be at risk of unlicensed medical practice or practice of psychology or even possibly nutrition and dietetics. But if you're licensed in your state but not others, and your client is in that other state, the remote state, you could be at risk of unlicensed practice of medicine in that state. Now, some of our clients are licensed providers such as medical doctors, psychologists, chiropractors, and they present a strategic question. Is it better to continue their coaching under their licensed practice and try to get a license typically for MDs in the remote states where they want to offer telehealth services? I would say by and large, yes, because there are many vendors that will help you get a license in those states. But another idea is to have a hybrid model where they see the patient as a licensed provider in their home state and then style themselves as a health coach in states where they're not licensed. This has some pros and cons. Again, we can talk more live. But using a hybrid model requires a bit of skill and savvy and an understanding of the legal and regulatory risks and how to mitigate them. I had someone say minimize. No, we don't minimize, but we mitigate. So here are three, to the extent we can, here are some three risk mitigation strategies we might use. One, if you're functioning in a health coaching mode, only avoid diagnostic categories and language such as depression and obesity. So speak in coaching language, like talking about habits, motivation, and goals. That's coaching language. Two, even if licensed, for example, as an MD or a chiropractor or psychologist, prominently disclaim your role, oftentimes with an asterisk or a box on the consent form or the disclosure form or the website bio or all of the above, so that you qualify your use of a professional title such as doctor. And three, limit the kinds of services you offer so that they don't cross the line into diagnosis and treatment of disease. For example, reviewing and commenting on lab tests. Health coaches want to do that all the time, but I would consider that a clinical function in the eyes of a regulator. Whereas telling someone to keep a food diary is just telling them to keep a diary. So thanks for watching. If you still have questions, please click on the link below, cohenhealthcarelaw.com/contact, to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.